call October 27th, 2021 meeting of the Cumberland Planning Board to order. Roll call. Ms. Frashich, Mr. McDonald, Mr. Butler, Mr. Scown, Mr. Bush. Here. Ms. Reese.
Here.
Mr. D'Ambrosio is absent. Mr. Costa. Here. And the chair is present. Before we continue, I'd like to note that this meeting is also being held virtually on the Zoom platform. If you have an interest in an item on the agenda, we will turn on your audio and promote you to a panelist as the item is called. If you would like to comment or ask a question, please raise your hand by clicking on the button labeled raise hand when the chairman opens the floor for public comment. Thank you. Next item of business. Approval of the planning board minutes of September 25th, 2021. Are there any additions, corrections, or deletions? And if there aren't, do I have a motion?
I'll make a motion.
Ms. Reese.
Make a motion to approve the
Motion.
meeting minutes of September 29 as presented.
Thank you. Do I have a second? Second. Second by Mr. Costa. All in favor?
Aye.
Opposed? Ayes have it. Mr. Stevens, director's report.
Yeah, Mr. Chairman, just have a couple things to mention. One, it appears that the elevator has been fixed. Here's the elevator's been fixed at Town Hall. So we'll be relocating there next meeting next month. And also want to make you aware that BVP prep is going to probably be on your agenda next month. They have an expansion proposal.
Thank you, Mr. Stevens. Item number 4, zoning board of review recommendation, dimensional variances, owner applicant Rodas Construction, location 49 Rhode Island Avenue, assessors plat 21, lot 139. The applicant requests zoning variances from rear yard setback and lot coverage to construct a garage. Mr. Modica.
Thank you, Mr. Chair. This property is located at the southeast corner of Rhode Island Avenue and Pennsylvania Avenue. It's 0.17 acres, about 7,400 square feet, includes a one-story single-family dwelling built around 1960. This property is part of the Waterman Heights Edition plat, which was laid out in 1926. Most of the lots in this plat are less than a quarter acre. Current zoning, though, requires a 40,000 square foot minimum. The applicant is proposing to construct a one-bay garage, about 297 square feet, and pave a driveway from Rhode Island Avenue to the garage. To construct the garage, the applicant is requesting a dimensional variance from rear yard setback and dimensional variance for lot coverage. Regarding the rear yard setback, this is a corner property that fronts on 2 public streets, so it has 2 front yards and 2 rear yards. The rear yard setback in this particular instance is opposite Pennsylvania Avenue, which is the south lot line. Required setbacks are 25 feet, and the applicant's garage will have a 10-foot setback. Therefore, the applicant is requesting 15 feet of relief. In terms of lot coverage, the maximum allowable lot coverage is 20%, or 1,481 square feet for this lot. Current coverage with the existing dwelling is 17%. By adding the garage and the paved driveway, brings the proposed lot coverage to 2,133 square feet, or 29%. So the petitioner is requesting relief of 652 square feet, or 9%. The planning department finds that the petition meets the goals and purposes of the comprehensive plan. This property is a corner lot where the required setback from the south lot line is 25 feet rather than 10 feet, where there's property only bounding on one street. Many homes in the neighborhood also have attached garages on similarly sized lots. Garage proposed by the applicant is relatively small and in keeping with the proportion and massing of the house on the property. And we find that the construction of the garage would not diminish the character or setting of this residential neighborhood.
Board have any questions for Mr. Modica? Pleasure of the board.
Make a motion that we send a recommendation to the zoning board that the application for Rodas construction at 49 Rhode Island Avenue is consistent with the comprehensive plan and include with the decision or the recommendation, Mr. Stevens' memo of October 18th, 2021.
I have a motion by Mr. Butler. Do I have a
Second.
Second by Ms. Brockman. Any other discussion? Hearing none, all in favor?
Aye.
Chair votes aye, motion passes. Item number 5. Town council recommendation zone change, owner applicant Mendon Realty LLC. Location 2359 Mendon Road, assessors plat 62, lot 17. The applicant requests that the zoning designation for the subject property be changed from R1 single family residential to C1 limited commercial. Mr. Modica.
Thank you, Mr. Chair. This is a 1.1 acre property, the northeast corner of Mendon Road and Forestry Drive. It includes a circa 1960 former Cape Cod dwelling with additions. The building was converted to a dentist's office, at least by 1993. The proposed ordinance would change the current zoning designation of R1, single-family residential, to C1, limited commercial. Planning department finds that the proposed ordinance meets the goals and purposes of the comprehensive plan, specifically goal E4 of the economic development element, which states, where appropriate, amend the zoning map to reflect present commercial, industrial, and agricultural uses. Since the property has been in commercial use for more than 25 years, changing the subject property zoning to commercial is consistent with the property's existing land use. Directly across the street is Mendon Plaza, a strip development that includes about 8 retail and commercial businesses. And the town's future land use map also envisions nearly 1 mile long mixed use corridor along Mendon Road, along both sides of Mendon Road, from Interstate 295 up to and including the subject property. Changing the property zoning would be consistent with the existing and proposed long-term land use of this section of Mendon Road. So the planning department recommends that the planning board forward a recommendation to town council to approve ordinance 21-28 with the following conditions. That the permitted use of the property be restricted to medical or dental office, which is use number 30 in the use table, and that the property comply with zoning article 6-10A regarding screening of trash containers.
Does anyone have any questions for Mr. Modica?
Chairman, just to let you know, the reason we came in, again, thanks Glenn for.
You have to go up there so that
we're doing it.
everybody can hear.
Okay. Hey. Once again, Mr. Monica has done a great job on and setting the table for what the client's asking to be done. But still, it's not part of the. Oh, I gotta also go here as well. Okay. I thought it was the mic. I thought it was the mic thing. Okay, it's fine. It's fine. This is you probably already know, this is Dr. Chan's office across from House of Pizza. And Dr. Chan would have been here this evening. He's in quarantine, unfortunately. Is not feeling all that sharp, but I asked Mike Dauber to come up with the site plan, and if there's any questions, it's an addition off the rear of the property, basically. I know that I believe what's explained to me is that it's in conjunction with his son's expanding practice as well. I was able to review Mr. Modica's recommendation, and I fully suspected that any positive advisory would encompass a limitation of the zone change or restriction of the zone change to the current use, and so that's something that we expected, and I know that the doctor has no problems with that restriction, and also I'm sure there's going to be no problem with respect to observing the requirements of the zoning laws with respect to the trash as well. And Mr. Darbo is here. Any questions about the actual, the site itself or the addition? Just in case, I wanted to make sure there was someone available to answer any questions you have.
Does anyone have questions? Oh, Mr. Scott, you have a question for Mr. Parrington?
Yes, the addition.
Yes.
How many more employees would be expected and how would that affect the parking?
Yeah, you do, Mike. That was obviously, when you look at the zone change, you look at whatever and nonconformities there may be, with respect to setbacks, lot coverage, parking's a big one, so we looked at that as well.
Michael Darbo, professional land surveyor. I believe I've been in front of most of you in the past. So on our proposed site plan, the existing parking is 28 spaces. So the zoning code for this particular establishment, if it were commercial, is 1 space for every 300 square feet. So we've done a calculation that 11 spaces would be required after the building addition is proposed. So there's additional parking there now. The parking that's there is sufficient, so there's no proposed expansion of the parking area. The building is proposed to be to the rear of the building off of Mendon Road. If you're facing it from Mendon Road, it's just over 700 square feet in size. We've proposed a rain garden for the increase in stormwater runoff, or I should say a vegetated swale in the back to the east of the shed, existing shed that's there, tuck it away out of the way and so forth. No additional grading and so forth is needed for the site, so it's a very minor addition, relatively speaking, to the size of the lot and so forth. No issues with lot coverage now or after the addition. And it's just a matter that it's not the right zone, Scott, right?
That's it. If I missed, Mrs. Khan, as you may have already you come across it, I mean, when you get, with our ordinances, with a lot of other zoning ordinances, sometimes the parking is gauged on, like, for instance, you have people who, how many people in a residential unit, or you have number of employees, or if there are company vehicles or things of that nature. In this instance, this particular use, parking the need for parking is assessed by the square footage. So that's really the only thing that we can follow, the only requirement we can follow. As a matter of practicality, though, I have asked Dr. Chan, we reviewed the plan, and he feels that given what his plans are for that there's going to be more than enough parking.
Any other questions?
I have a question.
Mr. Costa?
Mr. Partington, is that, I can't tell by these pictures,
Yeah.
is that white building attached to the brick building? Is that any? This white building here,
Yeah, I think that's an addition, isn't it?
Yeah,
Yeah.
That's probably-
the white portion. The white portion is, I believe, an addition that was done at some point at the rear of the existing building, this part here. And we're proposing to add on to that in the back of that.
okay, so that's not gonna be demolished,
No,
okay,
Any other questions?
thank you.
My understanding, will be back before the planning board for development plan review? Okay.
I'm not sure that it has to.
That's why I'm asking the question.
I know, and that's why I wanted you to have the right answer.
Yeah,
I'm not, did you look at that plan?
I didn't, I would say it's gotta go forward.
I don't have it memorized, the
I mean,
requirements.
I mean,
but it's a
unless-
Small addition.
Yeah, I mean, I'm trying to remember now. Is the actual designation or the commercial use of it automatically? I don't believe that it does.
Got it, but,
yeah, okay.
I mean,
Which,
whether, I
whatever
don't
it
know
has
if
to
we
be.
have to
it
do that
will be.
tonight.
No, no,
Because,
right.
but I don't think so.
Okay.
I think
Alright.
you should
But-
assume no. And if it has to be, we'll let you know.
Yeah,
Right,
that's,
and it would have to obviously do it because of the requirements. If it had to be, I don't think it does either, but if it does, it would have to obviously, I would think it would need that first before going to the council for a formal vote.
Yeah, so you should probably reach out to Glenn, like, in the next. couple of
Absolutely,
days.
sure.
Yeah, that's the reason why I raised the question.
Yeah, that's a good
because-
question.
Especially since it's been advertised as an amendment to the comprehensive plan and the future land use map. That's how it's advertised, am I correct?
Yep.
So it's not advertised as a development plan review, but then again, if they don't have to come before us.
I don't think they will. I'm
Okay.
pretty confident,
Sure.
but I always can look again
Mhm.
and make sure.
I'll be honest with you, it didn't even click
Yeah.
Yeah.
my
It's a
radar.
very small addition.
Yeah, well, the only thing that clicked with me is that,
Because my
more than
radar isn't
anything,
what it used to be, but, you know.
well, it's not just the small addition, which I don't think is a problem at all, but you're also revising the parking. You're adding parking spaces, correct? Or are you changing anything with the parking? It's the same exact layout as it exists.
Same exact parking layout. Basically, no grade changes, less than 12 inches around the new addition. So the existing parking is 28 spaces now, which is close to double what's required.
Yeah,
We're not adding any parking, we're not changing any
Okay.
pavement, we're adding the addition, and we're gonna provide a grass vegetated swale for the stormwater for the addition itself.
Yeah.
Nothing else is changing at the site.
okay, that kind of gives us a little bit more insight as far as the question of development plan review. My gut feeling, and not being an attorney, or legal of any kind, it doesn't seem as though it would have to come back to us, but we'll get that clarified.
Is it, for my parking, is it 10, I think? Is it 10, Ms. Sandra? I think it's 10 to put it into the development plan. review,
Yeah,
I
or
think.
it might even be 25. But you're not adding, so it's.
No, we're not adding, no.
Yeah, it's
I
just,
mean, like I said, I'm pretty comfortable, you know.
But I'll double check and I'll
Yeah.
check, Mr. Chairman, with the planning department and make sure that we're good on that.
yeah, because, you look at the plan and it's like, well, if you're not going to be
Mm.
changing anything other than putting that small addition on, my gut feeling is it wouldn't have to come before us. with
Yeah,
development
I
plan
would think
review.
so, but if we do, we do.
Yeah, okay.
And the state law, so when you talk about development plan review, the state law has two different types of development plan review. You're actually doing development plan review right now as part of your recommendation. So if you have any suggestions for the site, you can add those to your recommendation. That's one of the ways to do development plan review. The other one is the one that you're typically doing for uses permitted by right, that you are reviewing. So maybe that makes you feel more comfortable too.
Yeah, no, that's.
Yeah, well, I look at it as whether there is any major work being done, in other words, if they're adding parking, changing the configuration, then they're
Sure.
putting in
I mean,
all the kinds of drainage
Yeah,
and
doesn't-
lighting and.
Isn't it, for additions,
So
isn't it, what is it, a percentage of the existing building, or a
Yes.
percentage of the, if memory serves me, possession of,
Yes.
and then if you add X amount of parking spaces, that triggers it, so. I don't, but whatever it is, we'll double check that, Mr. Chairman, absolutely.
I'm fine with that.
Mr. Parker, one quick
Yes,
question.
sure.
At the very beginning, how many more employees could this building?
How many more? I don't know what the inside layout is, and I haven't discussed with the doctor the number of new employees that he expects, if any. I don't know if you have, Mike.
When I first started the project, so it's been a while now, he mentioned to me that they just needed more elbow room and so forth. That they weren't, because I asked him, well, do we need to provide more parking? And, there's the number that zoning requires, and then there's the actual number that people use.
Yeah, just
And
curious.
he said that what he had was sufficient and would be sufficient.
Right.
Okay.
How large is it? How many square feet?
About 720. It's coming out 24 feet, and that rear is, I think, 20, 30 feet, 29, 30 feet.
And it also observes the required buffer between commercial and residential. We have in our zoning ordinance, we have a special miscellaneous section that requires that buffer, so we meet that without any further relief.
That's good.
So I have the development plan review section up. It would have to be more than 25,000 square feet, or the expansion of 50% or more of the footprint of the existing building, or there's one more section that might apply, is including an increase in required parking
Correct.
of
That's
5
what
or
we're
more
doing.
spaces. And the planning director would have to make that call. So I don't think it meets, it doesn't meet the requirement for development. plan.
If I could, yeah.
Other than what you're doing right now, which is development plan review. It just happens to be a recommendation.
Regarding the parking, 720 square feet needs 3 additional parking spots. So that less than the 5, so I think it does not meet that requirement.
You said 11 with the new,
That's what's for the whole site after the addition is built.
right, so you don't need any new ones.
We have 28.
Right.
Yeah,
you
what
only
I'm
need
saying
11.
is the required is 3 additional for the addition, which we have more than enough space for. You read the section that said if more than 5 is required, additional parking spaces.
I thought you have,
We have more than enough. No,
right, so you
yes,
don't need any
right,
more.
correct. That's correct.
Okay, so you don't need 3 more or anything.
That's correct.
Okay.
Mike, do you have handicap parking there now?
The layout, I don't believe has any marked as handicapped.
I think you're gonna need 2
Yeah.
handicap spaces.
Okay,
That would be a building requirement.
right.
Oh,
Yeah.
big building code.
Yeah.
Yeah,
You wanna
that would
cross it
be
for
a
that.
building, yeah, we'll talk to Brad about that.
Board, have any other questions? Do we need to ask if there's anyone?
You can, you don't have to, but your
Yeah.
usual practice is to ask
Right.
if there's anybody in the audience.
In that case, I would guess, is anybody in the queue?
There are no attendees.
Okay, thank you.
I'll make a motion then that we send a recommendation to the town council. That ordinance number 21-28, an amendment of the comprehensive plan and future land use map in reference to Cumberland Assessors Plat 62 Lot 17 is consistent with the comprehensive plan and with the existing and proposed long-term land use for this section of Mendon Road. Would also recommend to the town council that they include in their approval that the permitted use of the property be restricted to medical or dental office, and that the property comply with zoning article 6-10 subsection A regarding screening of trash containers, and include in the recommendation of the town council, Mr. Stevens' memo of October 18th, 2021.
Motion by Mr. Butler.
Mr. Chairman, before,
Yep.
or maybe you get a second,
Yeah, do I have a second? Second by Mr. Scott, under discussion.
just on that zoning ordinance requirement, the site plan has to meet all zoning ordinance requirements. I don't think you should choose one as a recommendation. Just, I would leave that out. They have to comply with the zoning ordinance, all provisions of the zoning ordinance.
Unless they pre-exist. In
Uh,
certain cases.
I'm gonna say it depends on that one,
It
Scott.
does, I agree.
I think the question here is, was the second bullet point of the conditions regarding.
It looks like the issue
Enclosure for the trash.
Yeah,
in the,
that's a zoning requirement, so they
Yeah.
have to do that.
in the picture, it's the dumpster is not screened. So I think that's why it was being pointed out, is that it needs to be done.
Yeah.
Fine, thanks. I guess you can leave it in. If Scott, he might argue because it's pre-existing then. No, I'm just saying,
No, I
just,
don't
you can
think-
leave it in, that's fine. I didn't realize that's why they put that in,
It's a good point, though.
yeah.
But it's also a recommendation by the board, so
Right.
the council can decide that, it's not necessary.
No, that's fine. I didn't know why it was in, so I
Yeah.
take it back. I
Okay.
apologize.
That's okay. Any other discussion? Hearing none, all in favor? Opposed? Chair votes yes, motion carries.
Everybody have a great night. Thank you,
too.
guys.
You
Thanks,
too.
Scott.
You too, Scott.
Thank you. And item 5, Item 6, town council recommendations holding on ordinance, sponsor Cumberland Planning Department. Planning Department proposes to delete the holding ponds ordinance from the code of ordinances and add a revised version at section 6-16 of the zoning ordinance. Mr. Modica.
Thank you, Mr. Chair. As you know, at the past 3 meetings, planning board has heard projects that required several waivers from our holding pond ordinance. which we feel includes some very strict provisions. Since this ordinance was acted in 1989, the planning department decided to take a closer look to see if provisions were still relevant to the purpose of the ordinance, which is to protect the health, safety, and welfare of the public, avoid and lessen any potential hazards, and to protect neighboring landowners. This ordinance was passed in 1989 by the town council during the big real estate boom. And from reading the emergency ordinance enacted in August of that year, the initial ordinance of October, and the final ordinance in November, I think it's evident that there was great concern in town over the sudden proliferation of these holding ponds. And that the intent of the enacted ordinance was to segregate these holding ponds from neighbors as much as possible by placing them on one very large lot. I think that's why we have these restrictive provisions that require holding pond on one lot, 50-foot buffer, and deducting the basin and the buffer from minimum lot size. Now that more than 30 years have passed, we think it's worth taking another look at this ordinance. I'm not an environmental scientist, but I think best practices are to assess the site's topography, soils, and natural drainage, and other environmental factors to identify the most appropriate location for these stormwater basins or holding ponds. I think the existing ordinance is solely geared to protecting private property without regard to environmental conditions. So with the proposed ordinance and the changes, we've tried to achieve a balance between the two. And I'll quickly run through some of the more significant changes that we're proposing. First of all, is to move the ordinance from the code of ordinances to the zoning ordinance. Most developers and engineers are looking at our zoning ordinance and our land development subdivision regulations to see what is required. They're not looking at the code of ordinances. So we're taking it out of that and making it more visible. We're changing holding ponds to stormwater basin. That is more modern terminology. Getting more to the specifics, the original ordinance called for holding ponds to be located within a single lot. We don't think that is necessary if the site conditions allow that a holding pond or stormwater basin can spread over 2 or more lots, if that's where it makes the most sense, and that's the way you can create conforming lot sizes. We're also proposing to change the 50-foot buffer from the basin to 25 feet. We feel the 50-foot buffer is a little excessive. 25 feet would still provide enough distance between the basin and neighboring landowners. And then the buffer, we're proposing to make change the language slightly just to state that the buffer has to be between existing property lines. So to protect neighbors already there, not so that a buffer can still, a basin can still be built over property lines within a new subdivision. And not as in the case we had a few months ago, the buffer had to be from the proposed property line. And we feel that that would lead to the creation of larger lots than normally would be in that particular subdivision. And this leads to the next one, removing the buffer from calculating the lot size. We're removing that, but we're keeping the basin within calculating the lot size, just because we don't want a basin to be occupying too much of a lot. We don't want a house with and the basin right next to it. So we're leaving in that provision, but we're removing the buffer area. We don't see a need for that, and that just leads to excessive lot size. We're adding an operation maintenance plan that will be included in all new land development and subdivisions, and we are keeping the 6-foot chain link fence. We're also keeping the public hearing requirement. It's important that the public is aware when this type of development is occurring. And we've specified specific waivers that the planning board can grant, which is 16(6)(e), 4, 5, and 6, which deals with the fence, the 25-foot buffer, and the minimum lot size. Happy to answer any questions.
Or have any questions or comments?
I have a question. When there are two properties that are involved in the stormwater basins, are the deeds, is there anything in here? I didn't see anything, but is there anything written in the deed stating that the property owner is responsible for this holding?
It's here, it could be property owner, or it could be a homeowners association.
It is.
I think it's an obligation.
Obligation to disclose.
Section G. Is that right, Kelly? It is section G, Kelly?
Yeah, and I would say that,
You see?
Thank you.
we usually require those documents to be recorded, not usually, we always require them to be recorded. So even if it says something like, you know, subject to restrictions of record, which every deed says, the title searcher will find it. That's what we do even with homeowners association agreements. We record them against each and every lot so that when the next person's buying it, they know, you know, all of the restrictions and requirements for the property.
I think the difficulty lies with the person who is the seller, okay? Not making it well known to the purchaser exactly what's in the document. Am I
Right.
correct, Mr. Constant?
Correct.
Right, and
In other words, it's there, it's in black and white.
And there's really no way we can force that.
Right.
We don't read deeds when
Yeah.
they're recorded. So that's why it's recorded against the title. So if you're taking a loan out, you're gonna have a title search.
Mhm.
If you're not taking a loan
Right.
out, you're buying it at your own risk. But that's the best really we can do. That's really the best we can
And
do.
it's my understanding that the seller is sort of on the hook for
Yeah.
making sure that the purchaser knows what he's purchasing.
Correct. There's certain disclosure laws.
Correct.
And certain things must be disclosed where the buyer could actually go back after the seller for not disclosing certain
Right.
things.
That's what I read in here. And I think that's where some of the problems have happened along the way, is that the purchaser didn't realize because he wasn't told verbally, and he just has all this paper. And he starts signing off on, you know, whatever he needs to sign off on to close and so on. And all of a sudden, he finds out later on that, oh, nobody told me about this.
Having purchased waterfront property in Cumberland,
Yes.
I found out the hard way, and I was a young buyer. I was,
Yeah.
you know, second house, but I was very young, and I knew the waterfront property was there, but I didn't realize that the responsibility involved in it, and there was nothing in the deed.
Yeah, and I know that's where you're coming from. But
I
I
just-
think we do a better job today than we did, you know, 30 years ago.
And I just don't want that to happen to anybody else.
Yeah, so we're very careful about everything being recorded, like, you know, when we're recording a homeowners association agreement, I make sure it's recorded against every single lot in the subdivision. And that would be something that would talk about a holding pond, so it's not just a holding pond. It's all of their maintenance responsibilities now that we do homeowners associations. Okay.
Yeah.
If I may, Mr. Chairman,
Yes.
I also just wanted to, because you also get waivers for heights of fences. I just want to make sure you understand that if you compare this with a swimming pool, the building code, our zoning ordinance requires a 6-foot fence.
Mhm.
We can't enforce that because the building code says 4-foot fence. There's really not a difference. I mean, if you got an in-ground swimming pool.
technically, yeah.
So I would say you should consider potentially 4 feet. If you keep getting waivers that you're granting, I I would say you should consider that as well.
Relative to a basin straddling two properties, we've had in the past requests for, because I think we had one not that long ago, a few years ago, where they had exactly that situation, and they came before the planning board for a waiver because there was nothing that they could do otherwise.
Yep.
And I like that that's included in here. I'm a proponent of homeowners associations when it comes to holding ponds of any kind, because I hate to see the burden go on one or even two people who have to deal with whatever their neighbors are, whether it's leaves, grass clippings, whatever, it's going down the street and it's going into their holding pond, and they've got to clean it up at their own expense. And I'm a big proponent of homeowners associations, so that everybody shares in that, expense, definitely. Because you have to hire a licensed engineer to go in there and first of all inspect it. And then if he tells you you gotta do this, this, and that, then he's gotta come back again, and then all of a sudden you get the bill, and phew, it's like, quite a burden on that particular homeowner. Yes, Ms. McDonald.
The purpose of this, one of the purposes is to make sure that when property with a stormwater basin is transferred, that all of those who transfer the property notify the new owner. And when I read this morning, the ordinance 6-16, which has the red condition provision, page 3. Obligation to disclose. Actually 1. It says the developer or subdivider of property in the town shall develop or subdivide it separately. And I'm wondering about the wisdom of adding 2 words, the developer or subdivider or owner, to cover all instances. If an individual sells a house with a stormwater basin on it, and maybe this is getting too nitpicky, but it doesn't appear to me to be just developer or subdivider. An instance where property with a stormwater basin is sold by an individual owner is not required, the way this reads, to disclose a stormwater basin on the property.
If I read this correctly, it says to any person, partnership, corporation, holding company, or other personal or business entity. Does that not, isn't that all inclusive?
That would be the buyer. I don't have a problem with adding or
No,
owner,
neither do I.
but I'm just saying it's very hard to enforce. I'm just, but I don't have a problem with that at all.
Mr. Chairman,
Mr. Bush.
there's a lot, yes. I agree with you, and I'm wondering if we, as far as a homeowners association goes, and can we make it a requirement that in a new subdivision, there be a homeowners association so that the burden of maintenance isn't on 1 or 2 people, because the entire neighborhood is benefiting from having the proper drainage in the neighborhood, and I can't see putting that on 1 or 2 people. It can be quite expensive, I would think. Is that something we can consider or put in here?
That wouldn't necessarily go in a holding pond ordinance, and I'd have to look to see if it's already required by your regulations. And from a practical standpoint, that's what you require every time you have a new subdivision, whether it's, a large one or a small one. I can certainly look at the regulations to see if it is required now.
Excuse me, are all subdivisions required to have a homeowners association? Is that
That's
you're
what I'm
saying?
saying. From a practical standpoint, you require that every time you see a subdivision. I'm trying to look while I'm talking, but if it's not in here, we can add it, but it shouldn't go in a holding pond ordinance. It should go into your subdivision regulations. It's a different document. And in the meantime, as I said, you always require a homeowners association when you subdivide more than a couple lots, or even if it was a minor subdivision of 2 lots, and if there was a holding pond or any kind of common area maintenance type things, you should always require a homeowners association agreement.
Right.
The thing is, you don't necessarily have to have a stormwater basin. Let's say, for example, and we know where there's one in the northern end of town, where there are other drainage type structures, weirs and so on, that are used as a mitigating drainage facility, but it's not necessarily a holding basin. It's something that is done for mitigation purposes to slow the runoff down and meter it through an area and discharge it someplace else. So I don't want to complicate matters, but you could have a situation where it's not just a stormwater basin, it could be any other kind of a drainage structure. That's,
Or, I mean, you have one where you have a cistern that you just approved, Hidden Meadow.
Right.
You have open space areas that may need to be mowed or maintained. You have trees that need to be maintained, so it could be anything. And you do, as a matter of course, for the last probably 15 years anyway, required homeowners association agreements.
that's the situation that I didn't actually, that's the one that I had in mind, was this the one with the cistern.
Oh, okay.
Yeah, that's why I didn't want to get too specific as to where, this at northern end of town
Yeah.
and a mitigating structure, but yes, that particular one, and that's the one that comes to mind for me in particular, is the cistern.
I'm also not, I'm in favor of 99% of this. I'm not certain about changing the 50% setback to 25 feet, 50 foot to 25 feet. In a new large subdivision, it doesn't seem like it's much of a problem, but I know this came up initially during the recent subdivision that was proposed, I think it's by Mr. Menard, which is 3 lots, and became a problem with the holding pond that he had, the retention pond, with distances from lot lines and things like that. And I think with smaller subdivisions like that, where people are trying to shoehorn a number of lots into a small area, even though we had enough land to do it because of the, I guess the dimensions of the outline of the lot, it was difficult to do without putting in these kind of very strangely shaped lots in order to get it all in there. And then we're encouraging smaller setbacks, which really helps them to get those 3 lots in there. We're really trying to keep from developing according to the comprehensive plan. One of the problems is overdevelopment in the future, especially in the northern part of Cumberland. And so I think it allows people to take those small areas of land and, you know, really stuff more lots in than they normally would if they stuck to the provisions we have right now for these types of setbacks. I'm not really for encouraging more building, and I think that simply helps a builder do that. So I would like to stay with 50-foot setback. They say it's arbitrary, but kind of 25 feet is arbitrary too.
I don't think, isn't the 25 feet from DEM?
It's derived from DEM, we wanted to be more consistent with DEM regulations.
Yeah, and it says, DEM says setbacks from structures, roads, and parking lots. It sounds almost like it's more commercial area.
In the Menard case,
Mhm.
even if we had the 50-foot setback, they would still meet that requirement because their basin was 50 feet from existing property lines.
In the southern one, and I thought it was quite close, no?
from their new line. So they were too close to their new subdivision lines.
Isn't that too close? But that's, right,
So
so they were too close.
They were too close to the new lot lines, and our thought was ensure that this basin is not close to existing homes, existing neighbors. And, it could be at the developer's discretion, like we were saying, to put a basin over several lot lines, so it straddles several lot lines, if that makes sense.
Right.
So there's kind of a give and take there.
I'm thinking of different scenarios, and one would be a very large subdivision, 10+ lots. Okay, versus, a 2, 3 to 5 lot subdivision. What does it look like? Okay, and what it seems to be the most practical. And also looking at that, as far as what are we trying to achieve? And this is, Mr. Bush, I think this is kind of some of where you're going. Is if you're looking basically for the health, safety and welfare. You're looking for what, a safe distance from a particular point to the edge of the pond, or the highway, I believe is like sort of the high water level of the pond, wherever it's, designed to be at, the maximum height. What are the scenarios of trying to versus the 50 feet and the 25 feet? And I'm trying to visualize it, because this is something we're talking about, and you can look at it on paper, but in the actual application of it, what are we looking to achieve between the 25 and the 50? If what's to be gained, or what is lost even by going one way or the other? But I still look at a very large subdivision versus a very small subdivision. Obviously, that stormwater basin is going to be smaller for the smaller subdivision. But then again, the constraints that you have are the shapes of the lots. Okay. So I'd like to hear from the rest of the board. I'm just trying to throw some stuff out there, and it's just the time to kind of hammer this out. I mean, I'm comfortable with holding on with the recommendations based on the state, requirements. But then again, Mr. Bush makes a very valid point. So the question is what is the board comfortable with? Or should we even ask the director of public works, say, he's the the pro from Dover and things like this. Now, the one thing I do know, because I've had some experience with it, when you have a detention basin that needs to be maintained, maybe even repaired, you need a certain amount of room to work, even if you had to bring a backhoe in, how much room do you need before the backhoe ends up in the basin, that situation. So there's the mechanics of actually maintaining, because I had an experience that I had to go look at down in the town of Warren, where they had put a basin in, and I had to look at it at the time. I was working for a consulting firm, and I took all kinds of pictures, and it just came to look at, backhoe in there, and it's of a certain size, and all of a sudden the banks start to collapse because there's not enough room when it's too close to the edge of the basin and so on. But I think those are questions that I think Director of Public Works could help us out.
So I did speak with Bob Anderson, and we went through this revised ordinance. And he was fine with the changes, and speaking to your point, he thought 25 feet was good from a maintenance and access standpoint, exactly what you're saying. So he wanted a wide enough buffer so vehicles and other machinery can get there to clean out these basins. So he was good with 25 feet.
I know we do have some basins in town that they basically have nothing. And the fence is here and the curb is about 5 feet away to the roadway. And then you've got the fence and the basin is pretty much, there's really no room whatsoever, but this goes back several years before I think those structures were put in before we even had a zoning, even a holding pond ordinance at the time. And now they're so overgrown, I don't think anybody even knows the basins exist. Other than the fact that they see a fence and they say, what's that for? There's trees and what not going out of there, nobody's maintaining it.
So that's what the 25 feet is for,
Right.
making sure that it's maintained and that there's the operation and maintenance plan, that it is inspected periodically and cleaned.
Now, from the planning board, where does this ordinance go? Does it go to CBR or does it go to the town council? Council.
It'll be reviewed in detail by the ordinance subcommittee. They take a very active role on all ordinances.
Mr. Chairman,
Mr. McDonald.
I remember in some detail, but not in all of it, the Menard proposed development. Mr. DeMarco, what stopped? There was going to be a detention pond within just several feet of one of the properties. What was that in conflict with? Was it? One was the fact that the detention basin, he was trying to put the detention basin on one property. So if he were able under this to put it on two properties, he could have went. Did the 25 feet did the 25 feet vis-a-vis the 50 feet, did that figure into the issues?
I think, and so he was close to the new lot lines that they were proposing, and I think at its closest point, might have been 10 feet or so. So even the 25, he wouldn't have met the 25 foot. He would meet the 25-foot buffer in this ordinance because it's from existing property lines. But he also didn't meet the requirement that removed basin and the buffer from minimum lot size. So he needed a variance for that as well.
Okay, well, I feel a little better. I understand what Mr. Bush was saying. If you've got a lot of land, you've got a lot of leeway, whereas if you don't have much land. And one proposed development doesn't a policy make, but I know for a fact, someone who lived up there on Warrenton Trail, that there were a couple of storms, big storms, but there were a couple of storms where that entire land that Mr. Menard wanted to develop was literally underwater. And there's a creek or a brook that runs through there. And this fellow told me when it runs, it runs. So, all right, thank you.
Another question I had, one of the problems we had with the Menard development, I think, was that,
I just,
Sure.
we keep talking about a particular development.
Right.
I mean, I understand Mr. McDonald with, I just want you to be careful. They're not here. You may see it again. This is, I mean, you're kind of moving towards violating open meetings. So,
well, I'm just using it as an example, I'm just stating fact. I'm not making any judgment that hasn't already been made, and I can.
I'm just telling you, you
Right.
really need to be careful about continually talking about the same development that's
All
not before you tonight.
In a recent development in northern Cumberland on Wampum Trail, one of the problems some of us had was that the detention pond was also at the other end of the pond, was about 10 feet from one of the proposed homes. And I think I was not the only one who had a problem with that kind of a setup. It's not great design. So I'm wondering why there's not a proposal in here for how far it must be from a home or any structure attached to a home. So that can be headed off up front, so we don't run into that problem again.
It is 25 feet.
How about 50? 25 feet isn't very far from that door, you know? I'm not shooting you guys. All right, well, it's 24 feet to that wall from me over there. So my little measuring device here. So if you're sitting on your back deck, that's where the holding pond would be. Right there. I don't think that's, a proper distance. But again, I listened to the rest of the board too and see what they have to say about that.
Mr. Chairman,
Ms. Butler.
if the ordinance said 50 feet, we would still have the leeway if the applicant wanted to apply for one to provide a variance, correct? I mean, I believe the project in North Cumberland that was only a couple of feet from the house, I believe we were looking at the potential for a variant, 47-foot variance, so that it could be that close to a structure. So I would agree with Mr. Bush. I would be comfortable with leaving it at 50 feet. And if there's a particular project where 25 feet or something in between made more sense, considering that as a variance.
Mr. Chairman?
Yes.
I just want to take the opportunity too, because when we were going through this, I think it's important to mention that one of the first things that this ordinance says is when a landowner or developer has demonstrated to the town that property cannot be developed without an above-ground stormwater basin, it shall be consistent with this article. So, I mean, I know when I was planning director, I always pushed back on holding ponds at all. Asked for underground water treatment facilities. You remember Okanite, right? No holding ponds there. So the first thing the planning board should be looking at is why do they even need a holding pond? Can they do it underground so that nobody can see it? So I just wanna, I mean, you can do whatever you want with that, but I've just taken the opportunity to kind of highlight that this is only if they can't do it any other way, right? Manage that water.
So I raised that question on a previous project came before us just recently. And I had asked specifically that question, why they couldn't use a subsurface structure. And they pretty much explained that they had a high water table in the area. Well, that's that's a good example. And I agree with you. I would prefer to see subsurface systems whenever they can be utilized. It's better for the health, safety, and welfare of everybody, because you don't have to worry about kids playing in there or getting hurt in there, or worse for that matter. But
And they're ugly.
Thank you.
most of them are.
They're pretty
Yeah.
ugly.
Yeah.
Hey,
I'm sorry,
Except for
Mr.
yours.
Costa.
thank you.
It's like a beach,
Thank you.
I think.
I have to agree with Mr. Bush. I think 50 feet should be there. I'm not, because mine isn't 50 feet. Not even close. So I think, and then if there's a problem and somebody needs the 25 feet, then they can come before us and we can talk about it.
I don't think it's a question of what they need. The 25 feet is, you just don't want to hand those waivers out willy-nilly.
No.
They'd have to substantiate that and have a really good, solid reason why they are requesting a waiver from 50 to 25.
Absolutely.
So, yeah, I mean, I guess I'll go along with and agree with Mr. Costa and Mr. Bush in that matter. And again, Mr. Butler, who said, if so be it that they need to come for a waiver, then they could come and ask for a waiver. But they have to substantiate it. It's not, and again, it's again from what Mr. Bush was trying to get at, to try to jam in, as many lots as possible if you can get these waivers. So that's not necessarily a good reasoning for, granting a waiver from 50 to 25, but in some other cases, there would be very good reasons for granting a waiver from 50 to 25. So I guess you have convinced me, so.
Well, and I think the reason why we have the ordinances is to be followed. And I can remember a discussion with you that you came up with a couple months ago, when you said, the reason why we have these ordinances in place is not to create waivers for everybody. So, and I agree with you. I think, they really have to prove their case to us.
But I like what's being proposed here much better, because it seems to be the situation that we're running into more and more, is that we've been asked for a number of different waivers to the holding pond ordinance. And I think, we need to tighten things up a little bit to make the ordinance work better for us than it has in the past. And granted that way back when they originally wrote up the ordinance, they were kind of flying blind at the time. And they were sort of, I guess you would say, they were going a little bit more to the extreme of trying to protect every scenario and situation that may come up. And practically, in a practical situation, it just doesn't work.
Mhm.
Mrs. Scott. I don't have any disagreement with the 50-foot either, but it does, this, I guess the state DEM says 25 feet is okay. So are we gonna get challenged on that every time that occurs?
I was just saying that to Jonathan, so, I have to look into this more, but I'm hearing that the next round of DEM regulations that's gonna come into effect is going to say that the municipalities cannot change the requirements, similar to the building code that I just talked to you about. The building code requires a 4-foot fence for swimming pools, and our ordinance requires a 6-foot fence. We cannot enforce that. So I can't tell you definitively, but yeah, I think they're in the process of changing the regulations. And what I'm hearing is DEM will control all this type of stuff. So even if you say 50 feet, it may be 25 in a few months.
Pretty soon they'll be allowing building on lots with 97% wetland. Huh?
Maybe, I don't know.
I think it's happening.
Makes sense.
Almost.
But,
Okay.
Mr. Chair,
Yes.
can't
Mrs. Reese.
we just leave the 50 feet for now, and then when the DEM changes their new requirements, then we know we have to go by their requirements, and what's to say their requirements is less than 25, so.
I think we could ask the solicitor.
Well, and you're making a recommendation, the
Hmm. Yeah.
council will be making that. So if the consensus is 50 feet, then I would recommend that you go ahead, make the motion, that's your recommendation. We'll, by the time it gets the ordinance committee, we'll have checked these new DEM
Right.
regulations moving forward.
Let me throw out one other thing, and let's say there's a circumstance where we have the 25-foot buffer now as part of our ordinance. And we run into a situation that we feel that because of the proximity of where the basin is, the size of the basin and so on, we feel that that buffer should be increased for safety purposes. Is that a scenario that could happen? And do we have any ability to increase the buffer?
Probably,
Okay.
yeah, I mean, I think the answer is it depends, but
Yeah.
yeah, I mean, you still have site plan review authority.
Mhm.
I think if it's just a simple buffer, and we're talking in just, we're guessing right now,
Yeah.
but if a project came up where, I mean, even like, look at steep slopes. If you had a slope like this and then a detention pond, would you allow that? I think that you could work around that. Anyway, the answer is it depends.
Yeah, well, I know it'd be it's sort of a hypothetical, but in the same circumstance. You look at it, could that happen, and do we have any ability to increase the buffer because we think it's in the best interest in health, safety, and welfare of, anyone who's going to be living, working, or whatever in the vicinity. So,
I just want to point out, Mr. Chair, we do have 3 attendees.
oh, we do. Good. Does the board have any other questions at this point?
I can hit it later if you want. It's up to you.
No, go ahead.
Okay. As far as the variances go from section 616E5, 6, and 7, I was just questioning why, I'm sorry, not variances, waivers. For instance, number 5 says this section of the ordinance states that the 25-foot buffer must be clear of buildings or structures, but vegetation may be permitted. Why would we give a waiver to that? They can have buildings or structures in the buffer zone? Or in some cases, I don't know why.
No, the intent was, where the board can grant a waiver for the 25-foot buffer.
Okay, so that,
So the buffer has to be clear of the building and structure, but no, obviously you can grant the waiver to be 10 feet from the building or structure.
all right, and the next one is about calculation of the lot size. Let's see. Can include the buffer zone, but cannot include the holding pond, correct?
It will be the holding pond / basin will be deducted from lot size, where we've excluded, we've eliminated the buffer. being
I
excluded.
understand that. However, why would we ever have a waiver for that? I know we can grant it or not grant it, but why would we allow granting a waiver of figuring the lot size using the base? I don't see it as something that would be a waiver.
It leads to, I mean, it can lead to significantly larger lots than are in the development. I think again, that got back to the original intent of the ordinance from 1989 was to put it on one big lot.
Right.
So we're trying to kind of bring it back a little bit and not create one lot that is out of proportion with the other lots on the property.
I mean, I agree with what you're trying to do there with the changes there. I'm just wondering what waiver you would give to that. You would state that they can.
That would be regarding minimum lot size. It would be if their minimum lot size was 40,000 square feet, and then you deduct the basin, and they had 35,000 square feet.
So they don't have enough.
They don't have enough, and that's where the planning board.
But we would say that we'd be able to give a waiver to that if we wanted.
Correct.
Okay. I wouldn't want to. The last one, number 7, all applicants will be required to submit an operations and maintenance plan to the Public Works Department that specifies how the stormwater basin will be maintained. Doesn't seem like that is something that we should, they shouldn't be allowed to ask for a waiver from the, shouldn't that be?
It's only 4, 5, and 6. No, so
Oh, it says and 7 down at the bottom.
I think I did. It was just hard keeping track of all the numbers, but it is.
I
It's just,
understand.
yeah.
Okay, so
it is.
we can strike 7.
Strike 7.
Okay, that's great. Thank you.
Any other questions from the board? Well, with that being said, Mr. Modica, since we do have attendees, I will open up the floor for any comment, public comment or questions. Just asking that any person who wishes to speak this evening, give us your name and address for the record.
If there's anyone on the Zoom call who wishes to speak, there's at the bottom of your screen, there's a raise hand icon with a hand. So if anyone wants to speak, please click that icon on the bottom of your screen. And no one has raised their hand, Mr. Chair.
Okay, thank you, Mr. Modica. Then I will close this portion of the public hearing and restrict comments to the board.
No one has any comments. I'll make a motion that we send a recommendation to the town council that ordinance 21-28, amending the code of ordinances and zoning ordinance to move and amend provisions relating to holding ponds from the general code to the zoning ordinance is consistent with the comprehensive plan. However, we would suggest 2 amendments to the ordinance, the proposed new ordinance. On line 64, change 25-foot buffer to 50-foot buffer. And on line 97, after the words the developer or subdivider, add the words or owner. And include with our recommendation, Mr. Stevens' memo of October 18th, 2022. Or 2021.
I have a motion by Mr. Butler. Do I have a second? Second by Mr. Costa. Any other discussion? Hearing none, all in favor?
Aye.
Oh, chair votes aye. And the motion carries. The next item on the agenda is public comments.
Again, we have 3 attendees. If any attendee would like to speak, please click on the raise hands feature at the bottom of your screen. And no one has raised their hand, Mr. Chair.
Okay, thank you. With that, we'll move on to item number 9, adjournment.
Make a motion to adjourn.
Motion by Mr. Bush, second by Mr. Scum. All in favor?
Aye.
Opposed? The ayes have it. Thank you, ladies and gentlemen.